Imagine waking up one day to find that the most popular rifle in America, the AR-15, is no longer protected under the Second Amendment. That's not a hypothetical situation anymore. That's exactly what's now being considered by the United States Supreme Court. The question before the court is straightforward but deeply significant. Does the Second Amendment guarantee the right to possess AR-15s and similar rifles? This case could become one of the most consequential Second Amendment battles in modern history. In today's video, we're breaking down the details of this major challenge, what it means for gun owners across the country, and how it could reshape firearm laws moving forward. The case at the center of it all is called Vermillion versus Cook County. The petitioners in this case are individual citizens, along with major gun rights organizations such as the Second Amendment Foundation. Together, they're challenging Cook County's long-standing ordinance that makes it a crime to sell, transfer, or even possess what the county calls assault weapons. Now, that term, assault weapons, in Cook County's ordinance covers over 100 different rifles by name, including popular platforms like the AR-15, AK-47, and many others. But it doesn't stop there. The ban also applies to semi-automatic centerfire rifles that have certain features, such as a pistol grip, a folding or telescoping stock, or even a muzzle brake. The plaintiffs argue that this law doesn't just regulate firearms, it outright bans some of the most common and widely owned rifles in America, rifles that are clearly protected under the Second Amendment. They claim the ordinance directly contradicts what the Supreme Court already decided in landmark cases like District of Columbia v. Heller and New York State Rifle and Amp, Pistol Association v. Bruen. Their argument is simple. If a firearm is commonly owned by law-abiding citizens for lawful purposes, then banning it violates the Second Amendment. This new case also builds on recent comments made by Justice Brett Kavanaugh following the Supreme Court's decision to deny review in a previous rifle ban case known as NAGR v. Naperville. Although that case wasn't taken up, Justice Kavanaugh made an important statement saying that the time will soon come when the court must take up this issue. The petitioners in the current case are now arguing that this is that time, that Vermillion versus Cook County is the right case for the Supreme Court to finally decide once and for all whether states and counties can outlaw AR-15s and similar rifles. Meanwhile, Cook County, the defendant, is urging the Supreme Court not to hear the case. Their attorneys argue that the court should reject it because, in their view, there is no circuit split among the lower courts that requires Supreme Court intervention. They also claim that the AR-15 and similar rifles are militaristic weapons and therefore not protected by the Second Amendment, attempting once again to have the court avoid reviewing a rifle ban. So how did this case make its way to the Supreme Court? Back in 2021, the lawsuit was originally filed in federal district court in Chicago. The plaintiffs challenged Cook County's assault weapons ban under the Second Amendment. Then in 2024, while the case was still pending, the state of Illinois passed a statewide law banning so-called assault weapons and high-capacity magazines. This new law, known as the Protect Illinois Communities Act, PICA, largely mirrored Cook County's restrictions, creating an even broader prohibition. Around that same time, the Seventh Circuit Court of Appeals issued a ruling in another case, Bevis v. Naperville, which upheld Illinois' state ban. The Seventh Circuit claimed that AR-15s were too militaristic to be considered protected arms under the Second Amendment. They went so far as to argue that firearms useful in military service could be banned by states or local governments. When the district court reviewed the Cook County case, it decided that it was bound by the Seventh Circuit's ruling in Bevis. As a result, the district court issued a summary judgment in favor of Cook County, upholding the local assault weapons ban. That decision is what ultimately pushed the petitioners to appeal to the U.S. Supreme Court, setting the stage for what could be a landmark ruling on whether Americans truly have the right to own AR-15s and similar rifles under the Second Amendment. Now, moving into 2025, right after the Supreme Court denied the Snow petition, the Seventh Circuit Court of Appeals once again took up the Cook County case for review. After considering the arguments, the Seventh Circuit ultimately decided to uphold the lower court's ruling, maintaining that Cook County's assault weapons ban was constitutional. In doing so, the court leaned heavily on its previous Bevis versus Naperville decision, continuing to treat AR-15s as the civilian equivalents of M16 rifles. Their reasoning was that AR-15s are simply too militaristic for civilian ownership and could therefore be banned by states and counties. And now, because of that ruling, the case has made its way to the U.S. Supreme Court, where the petitioners are urging the justices to finally take up this issue and provide a definitive answer once and for all. They're asking the Supreme Court to clearly decide whether Americans have the constitutional right to own AR-15s and other similar semi-automatic rifles, and whether any state or county ban on these firearms violates the Second Amendment. The petitioners argue that the federal circuit courts are deeply divided and confused when it comes to interpreting previous landmark rulings like District of Columbia versus Heller and New York State Rifleman Amp, Pistol Association versus Bruen. Some courts have acknowledged that AR-15s qualify as arms under the Second Amendment, yet still claim that they can be banned for public safety reasons. Others have gone even further, arguing that AR-15s aren't protected arms at all because they resemble military weapons. This inconsistency, according to the petitioners, has created a constitutional crisis. They believe the Supreme Court must now step in to resolve these conflicting interpretations and reaffirm that all firearms, including semi-automatic rifles like the AR-15, are arms under the Constitution and therefore protected by the Second Amendment. To strengthen their argument, the petitioners included a wealth of data and evidence in their Supreme Court filing. They presented nationwide surveys, production figures, and sales data showing that there are tens of millions of AR-15s in civilian hands across the country, not just in Cook County or Illinois. They also highlighted that AR-15s are overwhelmingly used for lawful purposes such as self-defense, hunting, sport shooting, and target practice. Their central point is simple. If the Second Amendment does not protect the most common and widely owned rifle in America, then, by the same logic used by the Seventh Circuit, no firearm would truly be protected under the Second Amendment. In response, Cook County filed its opposition brief urging the Supreme Court to deny review of the case. They repeated their position that the AR-15 and similar rifles are militaristic weapons that fall outside the scope of Second Amendment protection. Cook County's attorneys gave three main reasons why the Supreme Court should reject the petition. First, they argue that there is no circuit split. They point out that every federal appellate court to review similar bans, including the First, Second, Fourth, and Seventh Circuits, has upheld assault weapons and rifle bans under the Bruen standard. Because of that, Cook County claims there's a nationwide consensus, not a conflict, and therefore no reason for the Supreme Court to get involved. Second, they argue that this case is a poor vehicle for Supreme Court review. They claim the plaintiffs failed to follow basic court procedures in the lower courts, skipping key steps like discovery, and did not present admissible evidence proving that these rifles are protected arms under the Second Amendment. In short, Cook County accuses the plaintiffs of rushing the case through the system just to get it before the Supreme Court, without building a strong factual record. According to them, the court shouldn't take up a case that wasn't fully developed or supported by concrete evidence. Finally, Cook County argues that even setting aside all the procedural and technical issues, the lower courts were correct on the merits of the case. They maintain that rifles like the AR-15 are dangerous and unusual weapons, and claim that because they share similar characteristics with M16s and other military rifles, they fall outside the protections of the Second Amendment. In short, Cook County's position is that this case is flawed on multiple levels. They say it's procedurally defective, that existing court rulings already settled the matter, and that no conflict exists among the circuit courts. For that reason, they insist this isn't the right case for the Supreme Court to reconsider the broader question of rifle bans. At its core, however, this case represents something much larger. It's asking the Supreme Court to finally do what many Americans have been waiting for, to take up a state-level and county-level rifle ban and determine whether these restrictions violate the Second Amendment. If the court agrees to hear this case, the outcome could go far beyond Cook County or even Illinois. It could have a nationwide impact, setting a precedent that would either reaffirm or strike down similar bans across the country. A decision in favor of the petitioners could finally guarantee that law-abiding citizens have the constitutional right to own and possess these common and widely used rifles. Up until now, the Supreme Court has been hesitant to take up any major rifle or magazine ban cases. They've avoided them for years, choosing instead to focus on other aspects of the Second Amendment. But this time might be different. Justice Kavanaugh has previously stated that the Supreme Court would likely need to address this type of issue soon, possibly within a term or two. That statement has given hope to many that the court may finally be ready to clarify where AR-15s and similar rifles stand under constitutional protection. Now, the big question is, will the Supreme Court finally take this case and settle the issue once and for all, or will it be another promise left unfulfilled? As this case continues to develop, we'll be watching closely to see what happens next. If you found this breakdown helpful and want to support the channel, please like, comment, and subscribe. It really helps push this content out to more viewers who care about Second Amendment rights